What is up, everybody? We wanted to show you the result of yesterday's polls on the Supreme Court cases and what the Supreme Court actually ruled in each case. So we'll start with Brown v. Board of Education from 1954. The issue here is that schools in the South at the time were racially segregated or divided. So there were white schools and there were black schools in the American South. And this court case dealt with the issue of the Equal Protection Clause in the 14th Amendment, which says that people within states need to be given equal protection of the laws. So, according to yesterday's poll, 85.5% of you believe that the Supreme Court ruled in favor of Brown, which would say that school segregation is unconstitutional. And you were right. This was a unanimous decision that said that separate but equal educational facilities, which is the basis of segregation, violated the 14th Amendment. And so African Americans had a right to attend the same schools. This decision took a long time to actually implement. In fact, my mother, who grew up in Maryland, she remembers her schools being desegregated in the 1960s. So this court case from 1954, it did take a long time, but it did lead to the end of racial segregation in schools. Next case was Miranda v. Arizona from 1966. This had to do with an individual who was apprehended by the police, but was not reminded of his right to an attorney during his questioning. So the question was, does the Fifth Amendment, which protects you against self-incrimination, extend to the police interrogating a suspect? And the poll from yesterday, 65% of you believed that Miranda won this case, that the police need to inform a suspect of their right to remain silent and have an attorney. And you were right, a 5-4 decision in the Supreme Court, which says that police have to inform you of certain rights if you are being apprehended or questioned. They're now called the Miranda rights. So if in movies or TV shows you hear the police say, you have the right to remain silent, anything you say can and will be used against you in the court of law, you have the right to an attorney, those kinds of things, those are the Miranda rights, and the police are required through this decision to remind you of them. Third case, Texas versus Johnson from 1989. So this individual went to a public building, the Dallas City Hall, and protested the White House's policies by burning an American flag, which violated a Texas law at the time. And the question is this actually protected under the First Amendment right to free speech? And in our poll, 63% believed that destroying the flag in this case would not be protected as free speech. But the Supreme Court actually ruled in favor of Johnson. It said because this was a political protest, the Constitution allows for free speech, even if the court thinks that this is, or the government thinks that this is terrible or offensive free speech, it is still protected. So it doesn't mean you can go around burning American flags or anything like that. But in this case, because it was a specific protest against the government, it was protected by the First Amendment. Okay, Roper versus Simmons from 2005. This has to do with the death penalty for a minor. Christopher Simmons was sentenced to death when he was 17 years old. So does that constitute cruel and unusual punishment, which is prohibited by the Eighth Amendment? In our poll, 84% believe that Simmons won this case, and you were right, although it was a closer decision than you might think. So it was 5-4. And the basic ruling, this one's interesting, was that basically the whole world thinks that executing a minor is terrible and illegal, and therefore the Constitution should agree with that. So executing minors is considered cruel and unusual. All right, last one, Terry versus Ohio from 1968. This is a big one. A couple of individuals were seen acting suspiciously outside a store by a police officer. The police officer searched the individuals, and a weapon was found, and the individual was sentenced to prison. So the question is, does this violate the Fourth Amendment, which protects against illegal searches and seizures? And 79% said that the police did not have a right to search this individual without a warrant, but the Supreme Court disagreed with that. They said that this was a reasonable search because, quote, any reasonably prudent man would have suspected that Terry was a suspicious threat. And so this leads to a policy allowing police to stop and frisk individuals, if you've heard that before. So if a police officer arrests someone, they have a right to pat them down because of this case. And so the search and seizure protection under the Constitution doesn't apply in cases like this. This has been a controversial decision. It was regarded at the time by some people to be racially motivated. And in a lot of cases, people still look back to this as a case that allows for racial profiling. But it is the constitutional decision from the Supreme Court that says that stopping and frisking an individual to search for a weapon is actually protected under the Constitution. How'd you do? Anybody get all of these cases correct? Nice job.